Hi, everyone. Welcome to TCPA's Dirty Little Secret. B2B companies must comply to. While there's a common misbelief that TCPA doesn't apply to B2B companies, we're going to focus today on the components of the TCPA, TSR, and state regulations that do apply to B2B companies. I'm Eric Tehead, the Vice President of Marketing for Possible Now, and our presenters today are Steve Neidick, Director of Marketing Compliance for our sister company, Compliance Point, and Tony Jernigan, who is a consultant for Compliance Point. Two notes: we will have a Q&A session at the end of the webinar to answer any specific questions that you have, and we will send you this recording of the presentation after the fact. So with that, Steve, I'll turn it over to you.
Great. Thanks, Eric, and welcome everybody. Just a quick agenda recap here. So as Eric mentioned, we'll go through the TCPA, the TSR, but also state applicability. That's one thing Eric didn't mention there, is that a lot of companies, and we've seen this all the time. I'm coming up on 22 years at Compliance Point, and I can't tell you how many times I've heard someone say, well, we don't need to worry about the D&C rules because we're only doing B2B campaigns. And that is absolutely not the case. So we'll go over what B2B versus B2C campaigns can look like, talk about some of the key compliance considerations, and then dive a little bit into the state laws and where you need to pay attention to those state laws, talk about what those risks are and what the enforcements look like. We'll go over some best practices, and then finally at the end, we'll have a Q&A section. So basically, do telemarketing laws apply to B2B? Again, common misconception that they do not, and you don't need to worry about B2B campaigns at all. But let's break this down a little bit. So first, the TCPA and the telemarketing sales rule. Yes, they're both primarily focused on consumer laws, but, and this is key, business numbers could also serve as someone's personal line, and those are not excluded. So basically, if you're calling or texting what looks like a business number, but it's actually a cell phone that the person uses personally, consumer protections could still apply. So what does that mean? Consent rules apply regardless of whether you're making B2B or B2C calls, or if you're using an auto dialer. So again, you need to pay attention to the cell phone. If it's a business cell phone, is it truly a business cell phone, or was it a consumer phone as well? So you could be subject to the TCPA as well as the state telemarketing laws. And then even on top of that, there are certain states like Arizona, Louisiana, New Jersey, Texas, Wyoming that take it a step further. They even restrict manually dialed calls as well, which means even if you're not using an auto dialer, you can still run into compliance issues there. So it's important to know who you're calling, what type of phone number it is, and what your campaign's going to be. And then finally, remember that for TCPA purposes, texts are treated the same as calls. Calls are treated the same as texts. So there's no loophole for that. Whether you're calling, texting, or sending pre-recorded messages, you have to pay attention to what those consent requirements could be. And then, do telemarketing laws apply to B2B continued here? Tony, you want to kind of talk about these points here?
Absolutely, Steve. Thanks, everybody. That theme that you just touched on there, Steve, about dual purpose lines or dual purpose numbers. That's going to be a constant theme running throughout this webinar, right? If you're calling for true business numbers, then there are exemptions that apply, but because of that possibility of dual purpose numbers nowadays in today's world, it's just better to be buttoned up on all this stuff. So what we're going to do is sort of take a look at all the requirements that we would normally look at for B2C, and sort of do a compare and contrast analysis as to what B2B has in common with B2C, and as well as some distinctions and finer nuances between the two. So just to start off, just as we would recommend for business to consumer, we recommend that B2Bs have a do not call policy, and that you perform adequate training around that policy, and for callers to be scripted as well. So the D&C policy should at least outline how you comply with D&C requests, as businesses in most cases do have a right to ask you not to call them anymore and at least 10 jurisdictions. We're going to look at those here in a little bit. But of course, we think it's a good idea to honor DNC or do not text requests across the board, especially because of the dual purpose phone possibility.
But especially, let me just chime in real quick, Tony, and especially with the do not call policy, it's not something that's typically asked for. So if one of your agents does happen to get a request for a copy of your do not call policy, it's usually someone that's trying to get some money from you, so it's best is just to have the process to send the policy out to them, and usually they'll move on to their next person. So
yeah, good point, Steve. I was about to touch on that. So we recommend that if you have any existing policies out there that, there's some new rules in place, we would recommend that you update those policies to ensure that, you're saying you'll honor opt-outs received through any reasonable method as soon as possible, how you comply with the DNC policy requests, as Steve just mentioned. And again, we normally think of this just in the B2C world, right? But if you're calling personal cells, we think it's a good idea to comply in the B2B world as well. And then ensure your training on all this policy, right? And that your callers know how to respond to do not call, do not text requests, and possible, as Steve noted, and possible requests for your DNC policy, and how to disposition it in your system, right? Not only how to respond to the person that's calling, but also to how to disposition it in your system. We think it's a good idea in terms of scripting. We think it's a good idea that if you use scripting, that you should use scripting that identifies the caller and the purpose of the call, callback information, as well as, and this is where some of those state level requirements come in that Steve mentioned, call recording disclosure, for example. That should be provided on all calls if the call is recorded and monitored, of course. We recommend that it be provided regardless of whether you think you're calling in a one-party state or a two-party or all-party state. Also, and believe it or not, there's also these pesky permission to continue states out there, right, that require sellers to basically put the ball back in the court of the called party, if you will, after the introduction, and say something like, this is Tony calling from XYZ company for thus and so purposes, and can I provide you with those details? Something to put the ball back in the court of the call party. And many states that have those permission to continue and no rebuttal requirements do exempt B2B, but some do not. So they would still apply. So then for record keeping, pure B2B is generally considered to be outside the FTC's record keeping rule. And there were some updates that went into effect just last October. But the businesses weren't necessarily considered to be in scope for the record keeping requirements. But we still recommend maintaining the same evidence, consent artifacts, scrub timestamps, dialer mode settings, and opt-out logs. And this is all because of having the record puts you in the best position to defend yourself if there's a lawsuit against you, right? Especially because of the possibility of calling dual purpose lines. And this reminds me too of an important point, because you want a record of the call. We think it's very important that you require all calls to be placed through a centralized platform, right? So, we just think allowing calls from outside such systems or on personal phones is just fraught with potential issues, because then you don't necessarily have a record of the dial. So again, we just think it's a good idea to place those calls through a centralized platform that, keeps records for you.
Yeah, evidence is your best friend here. I mean, a regulator's not going to take your word for it. You're going to have to defend yourself with the evidence of the call logs and the scripting and the campaigns and things like that. So just keep that in mind.
All right. Telemarketer registration. This is a big one. So the B2Bs don't think that they have to register as a telemarketer. There are some 34 states plus the District of Columbia that require sellers in general to register as a telemarketer. But each of those has certain exemptions. And a common exemption is if you're B2B. But still, there are about 14 or so of those states that do not expressly exempt B2Bs. But if you're going to, here's an important point though, if you're going to rely on the B2B exemption, all of your calls must be B2B, right? You can't just be because you play some B2B calls. All of them must fit within that bucket, and you can't mix in B2Cs. If there is no B2B exemption in a certain state, you can look at other exemptions, right? Some states exempt publicly traded entities, or if you're only calling with consent, or some other possibilities. You'll see a note there that says, be careful with Texas, because, you probably, a lot of our listeners have heard recently that, there's this new Texas law out there that affords, well, it's not so much that it's a new law, that many of the requirements have been in place, but it's just that now the private right of action has been attached to many of the basically all of the provisions of telemarketing in Texas. So that means that, consumers have a right, they don't have to go through a regulatory body to issue a complaint, right? They can sue you individually. Texas does have a limited B2B exemption, but only if you're intending to, I think, resell property or goods, or use property or goods to recycle or manufacture. So again, just look at that and make sure that you're, you've got a defensible position that you think the exemption applies to you there. So as Steve mentioned before, right, the DNC suppression, that's a huge area of concern. And also for B2Bs, not only B2Cs. But for B2Bs in their own right, as some requirements specifically apply to B2B, but also because of the possibility, again, of those dual purpose numbers. There are 9 states plus the District of Columbia that specifically require B2Bs to honor DNC requests. But for obvious reasons, I mean, it just makes best practice sense to apply this across the board. The FTC does exempt B2B from the national suppression for true business numbers. And the traditional thought has been, therefore, that B2Bs don't need to check the National Registry for non-exempt calls. But because of the dual purpose numbers, we highly recommend suppression for the non-exempt calls against the national list and state list. Pennsylvania in particular, is one of the 11 states with their own DNC list. And, they specifically allow business numbers on their state DNC list. When Mississippi had their own list, B2Bs were required to scrub for Mississippi numbers on the national list. And we still think that that's a good idea. And
actually, let me just touch on that real quick, because they did state you have to check against the national list. So
right.
Mississippi said, yes, you can put business numbers in our state DNC list. And then about 6 months later, they did away with their state DNC list. But they were pretty clear. They said you still have to check for Mississippi numbers on the national list. So I just want to emphasize that point.
Yeah, good point, Steve. And then just earlier this year, Missouri proposed allowing businesses to add their numbers to its do not call list, but for whatever reason, that measure failed. And as Steve noted, consent, right? If you're calling, this can't be emphasized enough. If you're calling a wireless number using regulated technology, which includes pre-recorded or artificial voice, you must still gain prior express written consent, regardless of your B2B purpose. And that can't be overemphasized. And again, as Steve noted earlier, unsolicited, non-consented calls are prohibited to wireless phones, regardless of whether you're calling a consumer or a business in Arizona, Louisiana, New Jersey, Texas, and Wyoming. Next slide.
All right, let's get into some of these other things like caller ID, calling time restrictions, and guidelines, as well as monitoring enforcement. Caller ID rules still do apply. So even if you're calling a business line, your caller ID should be truthful, display a number that can actually be reached if someone calls it back. And then also it's best practice to monitor how your number is being labeled by the carriers or the apps. So if you're checking that and you find out your informational calls from an HVAC company, for example, are being labeled as spam or scam or telemarketer, it's probably a good idea to try to get that whitelisted so that it isn't being labeled that way, to reduce the likelihood of someone answering that call. Speaking about call time restrictions, federal law states you can only call between 8 and 9 p.m. local time. Important to note here, local time, right? Because we all know cell phone portability and actually VoIP numbers even, I mean, someone could be located anywhere in the United States or even the world. And you may not necessarily know that if you're just going by their area code. So if you know an address, try to follow the address or zip code of the state as opposed to the area code. Some states do have stricter rules when it comes to calling time restrictions. So again, most of those only apply to residential or consumer calls. So if you're truly calling business lines, B2B calls are generally exempt. But again, just to stay safe, you want to know what the applicable state rule is and document your basis on treating that call as a B2B campaign. And then lastly, monitoring enforcement as well as guidelines. It's critical to maintain, so to speak, an internal playbook. Document your practices, your procedures for outreach. If you're applying a B2B exemption, spell out why it applies, what conditions you're meeting there, and then monitor your teams for compliance-related matters and enforce those guidelines consistently. So this is an area that regulators are looking for just to make sure that you're trying to follow your policies and procedures there. Tony, anything you want to add to that slide?
No, I think you covered it all, Steve.
All right, some other key compliance issues, consent requirements. We talked about prior express consent versus prior express written consent. As Tony alluded to, even though we may be calling some wireless numbers, if it's a marketing campaign and you're using a regulated technology such as an ATDS, you're going to need prior express written consent. Whereas just prior express consent could be those informational type calls. So as long as the business that you're calling has provided that phone number when they signed up, that would be prior express consent to call those numbers. Like Tony mentioned, the do not call restrictions could also be applicable. Again, at the federal level, if it's true business line, it's not covered by the National Do Not Call Registry. But as Tony mentioned earlier, states treat things differently, like the Mississippi example he mentioned in Pennsylvania. We've also seen a case out of Colorado. This is many, many years ago now, but it was I believe it was a realtor that had published their landline as also their business line. So it was a residential phone and it was published as a business line. So they were getting calls for B2B campaigns. That consumer sued and actually won because even though Colorado does not allow business numbers to be on their state DNC list, again, it comes down to a dual purpose phone line, and that was what that call was about. So they did uphold that ruling. Important to know, you can't disguise a B2C campaign as a B2B, so you can't get around consumer restrictions by pretending your outreach is business. If the line belongs to an individual or a home-based business or it's their cell phone, you should treat it as B2C. A good example might be if you're calling to offer cable services, but you're ignoring DNC rules because it's a B2B campaign, calling someone at a business number, and you get a hold of them and they say, well, I'm not interested, or that's not my area here at work. Then to turn around that call and try to ask them if they need it at home. Do you need internet at home or cable TV service at home? So you want to make sure you're not disguising that and trying to use those exemptions in an inappropriate way. Like Tony mentioned, true business numbers don't need to check against the National Do Not Call list, except for Mississippi. Pure business landlines, generally safe from a federal DNC restrictions, but again, be aware of those state laws like Mississippi and Pennsylvania. And then like Tony mentioned, regardless of B2B or B2C, if a business asks you not to call them, they probably don't want to hear from you. It's best just to honor that across the board, regardless of those 10 states that require it versus the other 40 that may not. That's what generates consumer complaints, when someone asks you not to call them and then you continue to call them. And then finally, like Tony mentioned, emphasize record keeping. You need to keep those clear records of consent, any internal DNC requests, what your campaign practices are. And again, that's going to document and provide you with evidence you need to defend yourself if necessary. State law differences, we'll get into this. So again, B2B space, you can't assume the rules don't apply. Some states will impose those restrictions. It's going to impact your business calling. Again, Pennsylvania allows those numbers to be on the state DNC list. Mississippi, you need to make sure you're not ignoring those. And then again, Colorado and those home-based businesses, you have to be careful of all of those things. And then on top of that, there are several states, we've heard the mini TCPAs like Florida, Oklahoma, and Maryland. Those can apply even if you're dialing cell phones, even if it's a business contact. So just make sure you're aware of what those rules are. We talked about the internal DNC list obligation. So even though that there's 10 jurisdictions that require to honor it, it's best to do that across the board. Caller ID as well. For instance, South Carolina, if you look at their caller ID rules, South Carolina requires you to actually have a physical presence in the state if you're going to display a South Carolina area code. So important to know that. And then finally, like Tony mentioned, the call recording, there's two-party states, there's one-party states, there's all-party states. But again, it doesn't matter if it's B2B or B2C. If you're recording those calls, you should have your agent disclosing that those calls are being recorded. Risk and enforcement, it's an important one. So a lot of B2B marketers, again, assume TCPA doesn't apply to me. It's just a consumer protection law. And as we've talked about, and hopefully you're getting the gist now, that that's not the case. The TCPA does allow private lawsuits. Statutory damages can be high, anywhere from $500 to $1,500 per call or text. And again, that can add up pretty quickly if you're running campaigns at a large scale. Important to note, the plaintiff's bar does at times target even B2B campaigns. Courts have made it clear that businesses are not necessarily immune. We can use the example here of Chanette versus Porch.com on the Ninth Circuit. Porch.com was sending text messages to home improvement contractors. Mostly businesses offering client leads. But again, as you can imagine, they're calling contractors. They're probably getting a hold of a lot of cell phones. But they argued that the do not call protection shouldn't apply to them because they were contacting businesses. The court disagreed, pointing out TCPA specifically applies to any person or entity. So obviously that means a business can be sued, not just individuals. So the key takeaway here for B2B is don't assume you're in the clear. The risks can apply in consumer, that do apply in consumer campaigns, can also apply to B2B outreach.
Right. You see, that reminds me of, you know about this. We had a potential client reach out to us, and they wanted to offer businesses information on franchise opportunities, right? And they basically said, we think we're good. And by the way, this is a theme of everything we've already talked about. We think we're good. We're B2B only. We're just going to mass text businesses that we've basically scraped off the internet. Since we're not cold calling anybody, clearly they're going to be cold texting them, right?
Right.
But we think we're good. Would you, but we just wanted to check with you guys. Any concerns? Well, yeah, there's a lot of concerns, right? So, from both regulated technology perspective and the do not call perspective, right? You're going to be mass texting these businesses using no doubt regulated technology. So again, you need express written consent, and also you're likely going to be calling numbers that are on do not call lists, right? So again, that's just I think that sort of highlights and brings a lot of this that we've been talking about, all together here.
Yeah, and that's a great example, Tony. And unfortunately, a lot of companies won't bother to double check. At least this company checked to see, would there be any issues with this, when a lot of companies might assume there aren't any. So I'm just going to go ahead and do it. And then they're going to get in trouble before it's too late. So great point. Great real world example there. So let's talk about some of the best practices for B2B campaigns. The best practices can still apply, even though it's B2B. You should be obtaining clear and documented consent. While it may not be necessary, it's definitely going to help you from a defendable position. So some of those B2B calls could fall under exemptions, but consent is still your strongest defense, especially for pre-recorded messages, texts, or outreach to wireless numbers. If someone says, well, I never gave you consent, and you have evidence of where that lead came from, and you can clearly state or see that they entered their information, there were disclosures there, you have that consent. Scrub numbers against the applicable DNC lists regularly. Again, some states apply the do not call restrictions even to business numbers. So always scrub against any applicable federal or state lists to stay safe. Like Tony mentioned, training your staff on what those compliance obligations are. Make sure your sales and marketing teams understand where do the rules differ in a B2B world versus B2C. So many violations to happen simply because the frontline staff didn't know that there were nuances or that there were rules they did need to pay attention to. So important to make sure everyone's trained on that. And then also audit vendors and third parties. If you're outsourcing calling or texting, you're still liable, or you could still be held liable. So you need to confirm with your marketing partners or third parties that they're following the same compliance procedures that you are, and that they're adhering to what those rules are. And then lastly, again, keep written policies and compliance logs. Documentation, again, is your safety net. If you're ever investigated, you need to be able to show all of those compliance processes, training logs, things like that. So key takeaways, obviously federal and state telemarketers can apply in B2B context, so pay attention to that. State laws often do go further than what the federal TCPA or the TSR states, and a strong compliance program definitely reduces risk. It also builds trust with consumers.
Steve and Tony, thanks for your insights today. If anyone has any questions you would like to ask, please use the chat pane to send those to us. And as a quick reminder, we will send you the webinar recording if you would like to reference it or share it with others in your organization.
All right, let's jump into the questions. The first question is, employees change jobs. How do we manage wrong party risk on mobile numbers?
I'll take that one, Tony. Great question. A little bit unclear, though. I'm trying to think of this in the perspective of, really, are you trying to reach that particular employee? Or are you just trying to reach the business and it happens to be that employee's cell phone number you have? So there's a little bit strange thing going on there. But think about it from the perspective, if you're trying to reach their cell phone number, but it now belongs to somebody else, your consent is no longer there, how would you know it's wrong party contact? One way to do that is with the reassigned number database. So R&D would let you check to make sure that the person that gave you the consent and that owns that cell phone is still the person that owns that cell phone and gave you consent. Otherwise, you don't have consent to call that cell phone any longer, with regulated technology, that is, with an ATDS. Now, if it was a landline, there's no concerns with that. I'm sure you could find a phone number for that landline. So it's a little bit of a gray question, but I hope that answered it. Tony, anything you want to add?
I would just say too, you might consider running periodic, is this still you type validations, right? To either via email or whatever, so that, you're making sure that the person that you think you're getting and for the purposes that you want for that company are still legitimate and validated.
Gotcha.
Okay, great. Thanks, gentlemen. The next question, I think, Steve, this would be probably yours as well. Does an EBR let us skip consent or DNC for B2B companies?
Well, again, it depends on how you're placing those outbound calls, right? So if we're just talking about EBR, the DNC list isn't as important if they're landlines. Obviously, you have to check against your internal DNC list. So if an internal request comes after an EBR exemption, obviously it trumps the EBR, so that your EBR exemption would no longer be good there. But if your EBR expired from the DNC list perspective, you wouldn't necessarily have to worry about the national list, just Pennsylvania and Mississippi. For Pennsylvania, the state list, like we talked about in the presentation, Mississippi numbers on the national list, if your exemption had canceled. But if we're talking about regulated technology, so an ATDS, and you don't have express written consent, only an EBR, then no, that EBR would not do you any good. You have to make sure that you have express consent to call cell phone with an ATDS, or if you're in one of those more restrictive states. And again, this is assuming these are truly business-to-business campaigns, and you're not going to try to sell a consumer a product on a B2B campaign. Anything you want to add there, Tony?
No, I think you covered it, Steve.
Okay, in the enforcement actions you've seen, have courts been sympathetic to companies' best efforts to honor DNCs, obtain consent, use scripts, train employees, etc.? If we do our best effort, and even if we're not 100% there, is that taken into consideration?
Tony, you want to take this, or you want me to take a crack at it first?
Go ahead.
I mean, you know, obviously the courts want to see that you're not ignoring compliance entirely. So this is what it comes down to. If you have policies and procedures in place, you're trying to adhere to those, you're doing those safe harbor requirements, they could be more sympathetic to you, that you're trying to honor those DNCs. Or actually, I don't know, I guess maybe this question means an internal DNC request, honor DNCs. If we're talking about federal or state, yes, you want to have policies and processes in place. Try to qualify for that safe harbor with your script, getting consent, and you're training your employees. But that's not to say you're going to get entirely off the hook. I mean, you have to be able to document and provide that all as evidence that you're doing all of these things. And yes, they will take it into consideration. Not saying that they may not fine you at all, but they might reduce it greatly or give you a warning and tell you need to do those things. Anything you'd add to that?
Right. Well, I was just going to say, at least conceptually, that, the safe harbor that you were mentioning, that at least is supposed to count for something, right? If you do have all these compliance measures in place, and in addition to all the things I think you mentioned, right, you also want to make sure you have buttoned-up policies around this stuff. If you think you're exempt, define the areas that you think you're exempt, or and et cetera and so forth. But also, you have to be able to show that you have all these things in place, and that the outreach was the result of a mistake, right? In order for the safe harbor to apply 100%.
Exactly. I mean, if you're knowingly avoiding following something in your policy, and you're doing it over and over, if you're doing it willfully or intentionally, then yeah. It doesn't matter, everything else.
Okay, thank you guys. The next one is, if we buy B2B leads, what makes the consent usable for us, the seller?
I can take that one. I would just say that, we recommend doing the same thing here for B2B as we'd recommend for B2C in today's world. And that is, make sure you have proof of consent language that identifies you as the seller. And the channel that you'll be using. Even though one-to-one consent was struck down as an FCC rule earlier this year, there's still court decisions out there that at the end of the day, they're still looking at whether consent was clear and conspicuous, and that the plaintiff should have expected a call from the business. And we're seeing, and with the one-to-one consent being struck down, we're seeing, North Carolina proposed a law that was expressly one-to-one consent. They finally walked that back. But we're seeing more state laws being passed and proposed around restricting the transferability of leads, whatever that means. We'll be waiting to see what that means. But another option is to make sure that, the lead flow matches you with what the consumer is looking for, right? So that they can end up affirmatively selecting you with perhaps your own consent language. But again, make sure you have records for all this, and that you have valid consent. If you can't prove it, don't rely on it.
All right, great. So I'm on my last one. So if anybody else has a question, now's the time to ask it. So this question is, how can we tell if something's a true business line or a mixed-use mobile phone? And how should we treat those?
I'll take a stab at that one too. I would just say, unless you know, as a matter of certainty, that it's a true, I think we sort of pointed this out in the presentation, right? that unless you know that it's a true dedicated business line, default to the higher standard, right? So probably even assume mobiles are mixed use, which means getting express written consent if using automated technology, which includes an automatic telephone dialing system or ATDS, pre-recorded or artificial voice. And so that you don't have to scrub against applicable DNCs if you have express written consent. If it ends up being a landline, then no harm, no foul. But if it was the other way around, you might have issues on your hands. And again, keep records. Make sure you have policies around this, as I noted before.
And let me just add, there are data sources out there. Now, they're not 100% foolproof, but there are sources of data you can go to see. Is the number a landline? Is it a business? Is it a residential line? Yeah, you're not going to be able to tell if it's a business mixed use. My personal cell phone is my personal cell phone, but I also use it as my business line.
Right.
It would show up as a residential line, as a lot of us probably do these days. But there are data sources to confirm whether it's a business line, a residential line, or a cell phone. And like Tony just said, if it's cell phone, I be cautious and just take it as a dual purpose instance and comply the best you can.
All right. It looks like that's all the questions. So thank you all for joining us today. If you want to learn more about Possible Now's marketing compliance solutions or about Compliance Point's advisory services, please reach out through the method there on the screen. And we appreciate all of you taking the time to join us today. And until next time, have a great day.